All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. We're here today in our case number CV140118, Snyder versus Entrust Fiduciary Services. Each side will have 20 minutes. We'd ask you to identify yourself and your client when you begin. We have conferenced this matter. We've reviewed the briefs and are familiar with the facts, and we look forward to your arguments. An appellant, obviously, you'll be responsible for reserving whatever time you want for rebuttal.
May I proceed?
You may proceed.
May it please the Court. My name is John Barron. I represent Entrust Fiduciary. We are the appellants in this matter in regards to the temporary conservatorship of Melvin Snyder. Your Honors, if I may, I would like to reserve 6 minutes of my time for rebuttal in this. The essence of the dispute, Your Honors, is, in short, the appellee, the heirs of Melvin Snyder, are upset that Entrust Fiduciary, a conservator, a temporary conservator, did not expend the funds of a protected person to engage in a will contest to challenge undue influence during the life of the protected person. That is the basis of their objection. That is the basis of their motions for summary judgment. The problem with that is that's not for what conservators are designed, and it is not for what conservators are authorized. Some of the salient facts that I believe are the most important. At no time prior to June 2011 was Melvin Snyder ever adjudicated incapacitated. More importantly, Your Honors, at no time ever was Melvin adjudicated to lack testamentary capacity. All transactions that are complained of within the litigation occurred a year or more prior to the implementation of the temporary conservatorship.
Was there a guardian, a separate guardian at the same time as the conservator?
Your Honor, I believe, and I may be incorrect, my client was not that guardian, but I don't recall as to whether the heirs acted as guardian in this case.
And would someone acting as a guardian be entitled to pursue a claim against a caregiver under the circumstances presented here?
Your Honor, the distinction that we have to draw is that the difference between exploitation and undue influence. An exploitation claim is based on a situation where a vulnerable adult, somebody determined to be a vulnerable adult, adjudicated to be a vulnerable adult during the course of the litigation, is, by virtue of his vulnerable status, assets of his are being transferred and utilized by another party, not for the adult's benefit. An undue influence claim is a will contest. It is designed to set aside an estate plan that was in place at the time of death. So to answer your question, Your Honor, with respect to an exploitation case, either a conservator may proceed or any interested party under 46456 may proceed with court approval on an exploitation. But on an undue influence claim, a will contest, and this is a will contest, number one, it's not ripe until the individual, the subject, has actually died. And number two, then an interested party, an heir, might engage in the will contest.
Would it make more sense, though, to litigate it? Let's say for whatever reason someone lives for an additional 10 years. Wouldn't it make more sense for a guardian to pursue, assuming there is a claim of undue influence, let's say the facts just seemed very obvious that someone had gone in, there's no evidence that that the person like Mr. Snyder was aware that a will had been changed or that a beneficiary designation had been changed. I mean, wouldn't it make sense under some circumstances to have a guardian try to undo what someone has done, even though the person is still alive?
Well, let's focus, number one, Your Honor, we're talking about a temporary conservatorship. Different set of rules apply between a conservator, even a temporary conservator, and a guardian. And I wanted to make that distinction.
And I guess my question just kind of goes to, I agree that this doesn't seem to be something within the purview of a conservator, but if it's the guardian and the guardian says it seems patently obvious that somebody has come in and wrongfully changed beneficiaries or payments on death, we're going to need to file a lawsuit. I assume they have to work with the conservator to file a lawsuit. Is that accurate?
Excellent question, and let me elaborate. The short answer is no. A guardian, and actually the imposition of a guardian, does not create an adjudication of lack of testamentary capacity. That's a huge point, and that's within the statutes, within the guardianship statutes. And the reason that is important, Your Honor, is because, let's take Melvin. Although Melvin lived a very, very short period of time, he could have, as your hypothetical suggests, lived 5, 10, 15 years. If a party were interested in preventing or addressing undue influence during the life of Melvin, they may file a petition for some form of adjudication of lack of testamentary capacity. That's not what occurred in this case. And the reason that it's important is because if Melvin has testamentary capacity, and the law presumes that he does, until the day he dies, unless he's adjudicated otherwise, he could wake up tomorrow absolutely lucid and decide, you know what? I don't like my estate plan. I don't like the changes I made to the POD accounts. I don't like the changes to the anything. I rescind what I've done. Matter of fact, I want to give it to somebody else. 3 years later, he wakes up with absolute clarity and lucidity and decides, for whatever reason in the world, he's going to change it yet again. So to litigate before a will contest, and again, remember the distinction between will contest and exploitation. To litigate will contests before an individual dies is a potentially fruitless and useless and expensive endeavor unless you have an adjudication that the individual lacked testamentary capacity somewhere
what
in
if
there.
There's some set of facts, let's assume some bizarre and extraordinary set of facts that really places the conservator on notice that in no real world is testamentary capacity present. Could the conservator then have a duty to act to ensure that there are no changes to the existing estate plan?
Your Honor, once the establishment of the conservator's got a myriad of duties, but one of them, under 145427, specifically states that it is to preserve known estate plans. You don't want to have a situation where a third party, even with the best of intentions, is making your estate plan or changing your estate plan. Melvin made his estate plan a year in advance. To the best of our knowledge, he had testamentary capacity. In fact, he had an attorney representing him and advising him during those changes.
Okay,
so,
but imagine a set of facts where the ward is just locked in, can't speak, can't write, can't express himself. The conservator becomes aware that during the period in which he was completely incapacitated, this potentially fraudulent new estate plan comes into being. Can the conservator attack it then?
I would suggest, Your Honor, that that is not the purview of the conservator. If the estate plan is altered during the time of the conservatorship, then perhaps one might make an argument because something is going on during the watch of the conservator. The interested parties, those that might have a stake in it, but then the problem becomes, well, Your Honor, how do you determine who has a stake in it? And you still have the subsequent problem, which is, while our hypothetical person may be currently locked in, using your phrase, that doesn't mean that tomorrow that individual will be. And, yes, sir.
Sorry, my hypothetical is even easier. If the suspicion is that that a document has been forged, that we don't think, not only did he not have testamentary capacity, he didn't know that that the documents had been changed. Does the conservator have any kind of obligation under that?
Are we speaking of testamentary documents, Your Honor, or those which would materially impact the value of the current conservatorship estate and the ability for?
Let's just say payable on death designations, but there's a concern that they were just forged without any knowledge of the by the ward.
In that case, you've got a fraud, you've got a potential fraud on the estate. The conservator may then engage in a determination based on cost-benefit analysis as to how much money it is going to cost the protected person's estate to proceed against this fraud and to
Does
recover.
the conservator, does the guardian have to be involved with that? Is that something you're saying the conservator would have the authority to do that?
The conservator addresses the financial aspects. So in a testament for pure testamentary disposition, that's still outside the purview of the conservator. It might be within the purview of the guardian. It is something that under the, if it's exploitation, then under the APSA statutes, there would be a report or something to the court. But unless it is materially impacting the conservatorship estate during that time of its existence, it's really not the purview of the conservator. The conservator is managing the assets for the protected person for their benefit during that individual's life. And if the only changes are truly post-death type changes and would not affect the conservator's ability to grab that asset and utilize it for the benefit of the protected person, then it's outside of the conservator's purview.
You made a comment at the beginning about, it sounded like you were making a distinction that there has to be a judicial determination as to whether someone is a vulnerable adult. Does the fact that, at least in this case, there was a conservator and a guardian appointed, does that make this individual a vulnerable adult under, is it defined under 46-451?
46-451, with respect to a vulnerable adult, the appointment of a conservator can occur for many, many different reasons. That does not ipso facto determine the existence of vulnerability. A person can be
I'm just looking at the definitional statute. It doesn't seem to require any sort of predetermined adjudicatory label.
But under 46-456, if you proceed forward, there must be a determination that the individual was vulnerable and that the actions of the individual were essentially a fraud on that individual and utilized, and that person was in a position of trust and confidence to the alleged vulnerable adult. So there's criteria which must be determined, and that is a judicial determination which must be made.
Is there a difference? I mean, it occurs to me that if we're talking about moving forward, if there's a guardian and conservator in place right now, to the extent seems to me there would be a presumption that there would be a lack of testamentary capacity, but that doesn't necessarily tell us about what his capacity was prior to the appointment of the guardian or conservator. Absolutely,
and Your Honor, I can, if I remember the case, but we do have a case in Arizona, and I can look it up. The law is fairly well established that the imposition of a guardianship does not affect or determine the lack of testamentary capacity. It might be indicia of a problem, and this court has acknowledged that there may be indicia. I believe it was Bakefield. It was an unpublished decision, but the logic of this court was, no, it does not create a determination of lack of testamentary capacity, but it is indicia that merits further investigation.
And is it on the conservator to conduct that further investigation.
No, it really isn't on the conservator. Because again, remember, the conservator is acting as a manager of the finances. The conservator is not trying to manage the post-death estate plan. It's not clearly defined, Your Honor. I have not found anything which specifically permits the conservator to go forward. It is a somewhat nebulous, but we know that if it affects materially the ability of the conservator to manage the estate on behalf of the protected person and care for them throughout their life, then certainly the conservator, it falls within the conservator's purview. Continuing with some of the facts that I believe are also salient. We talked about the fact that Melvin's estate plan, the stuff that is being complained of in the litigation, all occurred a year before the appointment of the conservator. So from the conservator standpoint, even, Your Honor, assuming this court were to determine that a conservator, a temporary conservator, has a duty to potentially undo estate plans that may have occurred during the conservatorship, this conservator was brought in with an estate plan to the best of the conservator's knowledge that was done by Melvin while he had capacity with the assistance of counsel. Another very, very important fact in this matter, Your Honors, in its order of December 12, 2013, the trial court specifically found that in trust fiduciary, as the temporary conservator, breached no duty that it owed as conservator to the protected person. Well, implicitly, therefore, it must have found that a greater duty existed, and we can discuss and debate that. Your Honors, I apologize. I'm running to the limit of my time. Are there any other questions that you might have of me at this time? Thank you.
Good morning, Your Honors. Jean Badarak-Gale. I'm representing the estate of Melvin Snyder, that is the decedent's estate, by and through its personal representative, Larry Snyder. May it please the court. This case is really not about a will contest. While the theoretical issues that are discussed here today are interesting intellectually, this case is really about an objection to an inventory and an accounting which were filed by the conservator. The objections were both procedural and substantive. The accounting was filed 4.5 months after the death of the protected person. The inventory was filed shortly before that. The statutes provide that the inventory rules of probate procedure require that provide that the inventory was supposed to have been filed 90 days after appointment. In this case, our contention as a side matter was that had that inventory been filed in a timely manner and had it contained a notation of a potential claim against Mrs. Mosley, both with respect to undue financial exploitation and undue influence, that would have given notice to the heirs of Mr. Snyder. But that's really a side issue. Pardon me?
Wasn't it the heirs who got Entrust involved in the first place?
It was, Your Honor. It was and they were aware of a certain amount of financial exploitation, but not about and the details of that was considered confidential information by the conservator, and so not provided to the heirs.
But they had standing, should they have chosen to do so, to seek relief under APSIT.
They were. And that's precisely why we didn't object in terms of the accounting, or in our objection, we did not file a claim that we had the expectation that the conservator should have filed a lawsuit or should have taken greater protective action within the conservatorship. That's simply not part of our objection.
So what should the conservator have done?
Well, the conservator should have obeyed the court orders that said she was supposed to inventory and take title to the property, which she did not
How
do.
would that have changed anything from your client's perspective, from the estate's perspective?
Well, had the inventory been filed in a timely manner, they would have been given more notice of the information.
What would more notice have done for them?
I think they probably would have hired counsel at that point. They were unrepresented throughout.
Okay, they hire counsel, but what could counsel have done for them?
They could have filed their own claim for financial exploitation.
And
Any interested
Didn't they do that,
person.
though, after Mr. Snyder died?
They did, but at that point, I mean, what happened was the decedent's estate was prejudiced by the fact that upon appointment as personal representative, and you'll see this in the inventory, in the accounting itself. The accounting itself says that the title to the vehicle was not in the name of the estate during the conservatorship, and that the caretaker was still in possession of the vehicle more than 10 months later. So she had not collected the vehicle. She had not recorded letters of conservatorship. So what the decedent's estate walked into was the need to collect personal property, which was not fully inventoried, from a residence that belonged and was occupied by someone else. And it was prejudicial to him. And so the claim had to be made. He had to file a lawsuit to be able to get at, to be able to address many of these issues. The conservator could have taken other action within the conservatorship short of filing a lawsuit. She could have requested a protective order. She could have asked for the caretaker to be removed as the trustee of Mr. Snyder's revocable trust. She could have taken.
Why would she have done that?
Well, I think there might have been a risk to the estate. She was making, Mrs. Mosley, the caretaker, was making claims to property.
But isn't it true that the conservator's duty runs to the ward and not to estate beneficiaries?
It is, and in this case, she has a duty to collect the estate and deliver it to the successor. In this case, the successors happen to include the heirs.
Well, but the conservator isn't there as a matter of law preparing for death. The conservator is there
Correct.
for a certain amount of time, and in this case, I'd point out, going back to your inventory argument, the permanent letters were never issued. And as I understand it, the inventory was required by the court to be filed 90 days after the issues of permanent conservatorship, which never even happened.
Well, the court order did not comply. The court order, as prepared by Conservators' Counsel, did not comply with Probate Rule 10.
Well, but it was still a court order.
It was.
And it was not challenged.
It was not.
Okay. So when you say the conservator's job is to marshal assets and deliver them to the estate, that assumes that soon there's going to be an estate to administer.
Well,
the conservator, as I understand it, is there to manage the assets of the ward during the ward's life and simply leave the estate plans to the fulfillment by the PR.
That is correct, Your Honor. The duty to deliver the estate could have been to the protected person if he recovered, or it could have been to a successor conservator. But the point is, she is required to collect and deliver that estate in accordance with the instructions of the court. It is, and the estate plan. So my analysis is that once the court takes jurisdiction of these assets, they retain jurisdiction, whether it goes through a subsequent probate or whether it gets terminated by the court.
But how does anyone know that there's a duty to prevent Ms. Mosley from using a car, for example?
There is not, because it is an asset of the estate.
Well, what if the asset was being used by Larry? Would the conservator have a duty to get
Yes.
it back from Larry?
Yes, she would.
So the ward can't lend out his property, can't decide how to live his last days, or what to do with his property while he's alive at all. He needs to become sort of legally selfish.
The ward, I'm sorry, I don't understand the question.
Well, I'm saying, if it's your contention that the conservator would have a duty to take all loaned property back from the ward's children even, the intended beneficiaries of the estate, that's a duty that I haven't found anywhere in the statutes.
Well, with respect to the vehicle, it should have been retitled into the name of the estate, not into, it remained in Melvin Snyder's name. That's the issue. The issue that I was addressing was the extent to which there's a factual basis for determination that the assets weren't collected in compliance with the court order to immediately retitle assets. The standard court order and specific court orders from the trial judge.
What other assets are there other than the car? And are you also suggesting, sorry for the two-part question, but are you suggesting that the conservator had any obligation with regard to payable on death accounts?
I'm suggesting that there is no distinction in the law between payable on death accounts and other accounts. She has an obligation to take title to the property. The determination.
How does she take title, though, to a payable on death, whether it's some sort of policy of some kind? What authority would she have to go in and change something that the ward did prior to her appointment as conservator?
She does not have the authority. Well, to the extent we're talking, I think you have to take each asset individually. She takes control of a payable on death bank account. Arizona law provides that you cannot have a conservator with a payable on death bank account. That's statutory. She takes title.
Saying the appointment of a conservator then would eliminate the payable on death designation of that bank account?
It brings it into the purview of the court for determination. And so, with respect to the recording of the letters of conservatorship, the law provides that once she records those letters, it comes under the jurisdiction of the court. And once she files letters of termination, if she filed her letters of termination, then the property passes either to the property passes to the personal representative. That's our contention. I think it is. I think that it is. This case, I want to distinguish. This case is also not about the incapacity of Mr. Snyder.
But so if he wasn't incapacitated at any point, and he has a bank account with a payable on death designation to his cousin, the personal representative has an obligation to change that designation at some point. Does anyone, whether it's a conservator or a personal representative, a guardian, who has the authority to change the payable on death designation if you're acknowledging that he didn't have there was no testamentary or concern about his ability to understand who he was naming as a payable on death?
Well, I'm not sure I understand your question, but our contention is that it's not her job to determine what his estate plan is. It's her job she's an arm of the court. She's supposed to take control of the assets, and it's the court's
But my question is, when you take control, does that somehow get rid of the payable on death designation of any asset?
It simply brings it into the court's control, and then when she is discharged, there is an order determining whether the asset would go to a payable on death designee or to the personal representative of the estate.
What authority does the court have to make that determination? The court would then be substituting itself for the wishes of the owner of the property.
Well, it's a statutory authority that the court has exclusive jurisdiction once it takes control of the.
Well, it has exclusive jurisdiction in rem, sure, but I don't
Correct.
See any provision that gives the court the authority to start making choices as to who wins and who loses.
That is what happens in the probate estate. That's not what it can be brought up in the conservatorship estate. The court can make permissible. It is permissible for the court to make orders to remove, for instance, a trustee on a trust for overreaching. The court could have that authority.
But you have a ward who's got testamentary capacity. You have a ward who has made a decision as to who the beneficiary on his death of an account will be. And the mere fact that he needs a conservator for some other reason now robs him of his ability to dispose of his property unilaterally?
It does not, Your Honor, and we have not made that claim. The basis of our objection is that the conservator did not deliver an estate, and this is acknowledged in her inventory and her accounting, that she did not deliver, she did not collect the estate that she was directed by court order to collect.
Okay, let me, do you
And preserve.
You represent Larry.
We represent the personal representative of the estate.
Okay. Do you represent any of the other intended beneficiaries of the estate?
I believe that in a fiduciary capacity, we have obligations to all beneficiaries and to creditors as well, Your Honor.
Okay. I'm only asking because I'm trying to determine your sense of the nature of any fiduciary duty that Entrust might have to other parties. Do you contend that there is a fiduciary duty by Entrust to anyone other than the ward?
We believe that there are fiduciary duties. Otherwise, she would not have, the guardianship, and the guardian in this case was Entrust Guardianship Services, which is a sister organization to the conservator. And it is clear that the guardian's obligations terminate upon the death of the ward. The conservator's obligations don't terminate on the death of the ward. The conservator's obligation goes through to the point where she is discharged by the court. So she has an obligation to the estate, to manage the estate, and that obligation goes to, it extends.
SAR has the duty to manage the estate.
Once appointed and once it comes into their control, but if the conservator hasn't taken control and handed off the property to the personal representative, they don't have access to that.
So you're not contending then that Entrust owed any of the children a fiduciary duty?
The basis of our objection was limited to an objection. It was a surcharge, a request for surcharge based upon procedural and substantive objections.
I think I need you to answer my question.
We believe it, but we believe that there is a fiduciary duty owed to heirs and to creditors, Your Honor. But that's not the basis of the objection.
Okay. So then, from the standpoint of what you're now characterizing as your objection, which is, I guess I could sum up as administrative irregularity, what prejudice do you believe flowed to the estate as a result of any lack of timeliness, assuming there was lack of timeliness, in the presentation of the inventory?
Well, Your Honor, we believe that the situation, what ended up happening is that the substance. So, are you just asking what procedural issues are?
No, I understand. You're saying that the inventory was late and it didn't really have in it what it should have had in it. What prejudice flowed to your clients? What's the basis for your claim to damages? If that's the only issue here, and that's honestly not quite how I understood it from your brief, but if that's the only issue here, what gives rise to damages from the inventory being 30, 40 days late in your view and not having a car in it?
Well, the inventory would have been due. The appointment was in June, so the inventory would have been in July, October, November. It was done in May, right?
Right, not according to the court's order.
Right, not according to the specific court's order. But the accounting was also due 90 days after the date of death.
I could just add to the same line of questioning. The personal representative pursued litigation against Ms. Mosley, correct?
Correct.
The litigation resulted in Ms. Mosley receiving some money?
The litigation, yes, and what we ended up being in a situation where someone else was occupying the property, waste was being committed on the property.
But my question goes to, it's hard to come up with any possible prejudice to the estate. I can see if there was some claim that in that period of time when an accounting should have arguably been presented, all of these assets were wasted and we can no longer go after Ms. Mosley for those assets. But here, there's not even a deficit that the estate is going after from Ms. Mosley. The estate's in fact paying Ms. Mosley something. So I'm hard pressed to come up with any prejudice from the delay, assuming there was a
The residence was recovered by the estate. The residence had a value of about $130,000. That was recovered by the estate. There was no recovery of the long-gone $120,000 that was taken prior to the involvement of entrust, and that appears in the record.
But did the estate seek the recovery of that, the long-gone assets that were taken?
I wasn't involved in the APSA claim, so I don't.
How could there have been any kind of claim when the estate ends up paying Ms. Mosley something?
Well, because there were issues surrounding, there were two issues. One issue was that Mr. Snyder had not paid Mrs. Mosley. He had not paid her for services that were provided during the year and a half that she lived with him, and so there was a claim that was owed. There was also personal property that belonged to Mrs. Mosley that had been collected by entrust as part of the conservatorship. We had to locate certain items of personal property that were clearly belonged to the family of Mrs. Mosley. The specific examples in the settlement agreement were the high school ring of her son from the year 2010 and her husband's gold wedding band.
Are you claiming monetary damages from that?
The nature of the settlement was, I don't know. I can't speak to the nature of that settlement.
I get back to now trying to understand the essence of your claim. What are you claiming monetary damages for if the only issue is irregularities with the accounting and the inventory?
The property had to be located. Well, arguably, had she delivered the estate, she could have delivered the estate to the trustee of Mr. Snyder's trust. She could have petitioned the court for authority to deliver the entire estate to the trustee of the trust, which is what his estate plan was.
All sorts of things could have happened, but we're running out of time, and I really want to know, how is it that the estate was actually quantifiably, recoverably damaged by those two administrative hiccups?
Because we had to file a separate lawsuit to recover the residence, which should have been part of the conservatorship estate delivered to the decedent's estate. The separate lawsuit would not have been required had she recorded the letters of personal representative. Now, whether there would have been a dispute, and damages are at issue still because...
Well, I understand, but and given the short amount of time you have, you've identified the separate lawsuit to recover the house. Is there anything else?
Simply the opening of the probate could have been avoided. Okay. So it has to do with estate costs and expenses.
It doesn't have to do with the merits of any gifts that were not made or were diminished in
No,
value.
Your Honor, and I just would ask you to consider the policy implications of allowing an experienced, licensed fiduciary to get a pass on not complying with specific court orders, ordering her to retitle the assets of an estate.
Not complying with the rule, though, the specific court order.
There are court orders which say, and she signed these orders, prepared these orders, and mailed them to the son, saying that she would retitle the property and she would record letters of conservatorship against the residents.
There's a rule that says your disclosure statement needs to be served 40 days after your answer. I guarantee you that 200 times a day, courts are entering orders that alter that time. Are you saying they're invalid?
I'm not, Your Honor. The timing of the inventory is not as important as the failure to retitle the assets. That's the crux of our claim.
Okay.
Thank you.
Your Honors, I waive rebuttal.
All right, thank you both for your argument. We'll take this matter under advisement and issue a decision in due course.